Special circumstances may allow a convict to appeal his sentencing deal. So a convict made a plea deal that included an agreement to waive his right to appeal the deal. Then he found out the deal included requiring him to take psychiatric medications. The lower court blocked his appeal due to that waiver. This is Dr. David D. Shine for Business Law 101. Petitioner Munson Hunter III was charged with 10 counts of bank and wire fraud for a scheme costing various financial institutions about $500,000. He entered into a written plea agreement with the government under which he pled guilty to 1 count of aiding and abetting wire fraud in exchange for dismissal of the remaining 9. The agreement included an appeal waiver under which Hunter waived the right to appeal his conviction and sentence. The agreement further provided that any modification of its terms must be in writing and signed by all parties. The trial court accepted the plea after deeming it knowing and voluntary. At sentencing, the probation office recommended that as a condition of supervised release, Hunter be required to participate in a mental health treatment program and take all mental health medications prescribed by his treating physician. Hunter objected to the mandatory medication part of the deal. The trial court told Hunter that if the treatment provider prescribes drugs, you should take them. The court then imposed a sentence of 51 months in prison, followed by 3 years of supervised release, including the contested medication condition. Hunter appealed, challenging the mandatory medication condition as infringing on his fundamental due process liberty interest in being free of unwanted mental health medication. The government sought dismissal of his claim based on Hunter's appeal waiver. Hunter acknowledged that he had knowingly and voluntarily signed the waiver, but argued that the appeal waiver is unenforceable when the disputed aspect of his sentence violates a fundamental constitutional right. The appeals court dismissed his appeal, holding that he did not qualify for an exception to his waiver. Somehow, Hunter managed to get his case before the Supreme Court. The High Court, in a surprise, reversed the lower court, holding that an agreement not to appeal a sentence is unenforceable when it would result in a miscarriage of justice. Therefore, it bumped the case back down to the Court of Appeals to examine Hunter's case more carefully. I want to mention a special promotion that we're running on our YouTube at Dr. Dave Saves America. We have passed 1,000 subscribers, and we're now on the road to 3,000 subscribers. And if you're interested, in the comments, tell us if you want Bad Deal for America or you want Decline of America. We will be having a drawing after we pass the number 3,000 in people who have posted that they want to be in the drawing and indicate which book they're interested in, and we'll be sending them that particular book. And we appreciate your listening, and we appreciate your participating. Thanks for joining us as we break down court decisions, business disputes, and legal issues shaping the world around us. If you've enjoyed today's episode, be sure to like, comment, subscribe, and share this with someone who wants to understand the law without all that legal mumbo-jumbo. Have an interesting case or business story you'd like us to cover? Send it our way. It may appear in a future episode. And if you've missed any of our previous segments or want to hear one again, check us out at our website, DrDaveSavesAmerica.com. Now let's all go out and consciously get along with our neighbors. Let's reduce the violence and discord in our wonderful country. This is Dr. David D. Shine for Business Law 101. See you next time.